Good afternoon, everyone. My name is Monique Jenkins, and I'm a research specialist for CNA's Center for Justice Research and Innovation. On behalf of CNA and the National District Attorneys Association, we welcome you to our virtual discussion on maintaining victim services during COVID-19. We want to thank Patty Powers and Jonathan Curlin of Equitas for their time today and for all the work that they've done with us over the past few months. We also want to thank you all for joining us today. We appreciate all that you do to keep our community safe. We hope today's discussion will be helpful to your understanding of maintaining victim relationships during this global pandemic. Today's webinar will consist of a brief presentation, and then we will open the discussion for Q&A. We've received a number of questions from registration, which our panelists will be answering. And with that, I will turn the discussion over to John. Thank you.
Monique, thank you very much for that handoff to me. And I also want to extend our appreciation to CNA and to the NDAA for hosting this forum and for inviting Patty and myself from Equitas to be participating today. And not least, of course, I want to thank everyone who took the time to join us today to participate and who have submitted already such thoughtful questions and what I'm confident are going to be further thoughtful questions throughout this conversation today. And our goal today is, while we're focused on the topic of how we want to be supporting victims of violence during a pandemic and extra steps we want to be taking and recognizing and perhaps managing some of the challenges, the goal that Patty and I are hoping to accomplish today is hopefully facilitate a conversation between all of us here in this forum, so that we can all bring our expertise and try to figure out a variety of solutions to either solve and or mitigate a lot of these challenges we're facing. So initially what I want to do, before we even unpack some of those issues, there's a couple housekeeping matters we want to address. And that first begins with introducing ourselves. As you already may know, I work for Equitas. I'm an attorney advisor with Equitas, which we're going to tell you a little bit more about in a moment. I've been with Equitas for about 3.5 years. Prior to Equitas, I worked for 16 years as a prosecutor in the district attorney's office in Berks County, Pennsylvania, where I served as chief deputy district attorney, a chief of trials, and assistant district attorney. I was responsible for supervising the prosecutions as well as personally prosecuting a variety of cases in the areas of sexual violence, child abuse and child molestation, intimate partner violence, elder abuse, domestic violence, homicides, and working in facilitating relationships with multidisciplinary partners. I think it's one of the best jobs a lawyer can ever dream of. And the wonderful thing about working with Equitas is, even if I don't get to directly be a prosecutor anymore, I still think of myself in that role, and I get to work with so many folks from a variety of disciplines across our nation and indeed across the world. Let me virtually hand the microphone to Patty so she can give you a little background and intro about herself.
Thank you so much, John. And I also want to join with John in thanking CNA and NDAA for their fantastic leadership in making this information available. And thanks to all of you who have somehow carved out time of your very busy and tough schedules to be with us today. We're all hoping to learn from each other. I'm also an attorney advisor with Equitas, and I have been with Equitas now for 5 years. Before joining my colleagues at Equitas, I was a senior deputy prosecuting attorney in Washington State, where I had the privilege of not only supervising our sexual assault domestic violence unit, but also trying a high volume of cases in the areas of sexual assault, domestic violence, and related homicides. And I did this work for 27 years. I worked very closely with other multidisciplinary professionals and want to share some of that with you today as we delve into the topics we're going to discuss. While I was still a prosecutor, I was appointed as an HQE, highly qualified expert for the United States military, and I did work consulting on sexual assault and domestic violence cases for 5 years on an intermittent basis while I was still a prosecutor. I'm honored to be with you today and appreciate very much this opportunity to focus on the questions that you have as practitioners.
So hopefully some folks have already heard, if not most folks have already heard about our organization, Equitas. But if you haven't, I'm going to tell you a little bit about it now. Equitas, we're a nonprofit. We're based in Washington, D.C., and we're composed primarily of attorney advisors who are former prosecutors and are based all over the nation. I'm based in southeastern Pennsylvania. Patty's based in eastern Washington. And what our mission, goal, and purpose is at Equitas is to train, develop, research, and learn about best practices in the areas of prosecution, investigation, and advocacy for crimes related to intimate partner violence, sexual violence, human trafficking, and elder abuse. We do this through a mission that's intended to be multidisciplinary and collaborative in nature, as well as victim-centered and offender-focused. Let me tell you a little bit about how we accomplish that mission and ways you can utilize the resources we offer even beyond today's discussion. One thing we do is we have resources available on our website that are free of charge. As a matter of fact, all the services we offer are free of charge as we are grant supported. If you go to the resources on our website, you'll be able to see strategy articles, research papers, curated publications, as well as case law and statutory compilations on areas and subjects that are of relevance to the crimes of gender-based violence. Those can often be downloaded directly from our website. If they're especially voluminous, you may have to contact us as the size of them is too big to contain on our website. The other thing we offer are training events similar to this. Prior to pandemic times, there would actually be live-based trainings where we could travel to different areas and work with area people to give trainings in these different areas. Now we're doing mostly virtual and web-based training, which is essentially free to anyone who wants it. So the only thing that needs to be provided is an internet connection. If you go to our website, you can see a catalog or essentially a library of some of the trainings we've offered. The other thing we offer, and this is actually a lot about working at Equitas is fun, but what can be especially fun is the opportunity to give direct consultations. This is almost a little bit like when being on call when I was a prosecutor and working as an attorney. But what our consultation resources provide is we're available 24/7. And if there's a prosecutor, a law enforcement official, advocacy, or other allied agency who needs help or develop resources in a case, wants to find research or information maybe about a potential expert or just different approaches on an issue, we're available to assist with that. The other thing we do is we also trying to model, we recommend multidisciplinary collaborative models. And in trying to model that, we develop extensive relationships and partnerships with other national technical assistance providers. So even when we can't directly provide a resource, hopefully we can connect you with a resource through our network of someone who will be able to help you. To find the going-ons at Equitas, either new resources or publications we've developed or upcoming trainings or recordings of past trainings, you can go to our website, which is indicated here, equitasresource.org. You can also follow us on social media, either Twitter, Instagram, Facebook, and LinkedIn. I do want to note that the work that Patty and I are doing and the time that we're spending today, it's supported through a grant provided by the Office on Violence Against Women. If you disagree with any of the opinions or comments offered by Patty and I today, please don't necessarily impugn them to the Office of OVW, although I'm hopeful that they'll agree with everything we offer. So with that background, I'm going to hand things to Patty to sort of give to sort of set the table for some of our discussion of the questions we've received and anticipate hopefully some of the questions that will come up during our conversation today.
Thank you so much, John. Just to give us all perspective on the questions and the discussion that we anticipate having. First and foremost, it's very important that all of us, regardless of our role as prosecutors, advocates, or other allied professionals, we want to focus on initially recognizing the signs and symptoms of trauma. The offender has caused trauma to a victim, and the victim, against many odds, has made the courageous decision of making that report and seeking our professional service within the criminal justice system. We need to be aware of what the offender did in inflicting trauma and what some of the symptoms of that trauma are with each and every victim. And we all know as service professionals that the signs and symptoms of trauma are highly variable among victims. There are some commonalities, but we always have to make sure that we understand that there is a great deal of variation. In addition to focusing on the signs and symptoms of trauma, we need to be very much aware that the pandemic also impacts everyone within our communities and certainly impacts victims of crime as well. Support systems may not be intact. There may be concerns with trying to reach law enforcement or other criminal system authorities and not being able to do so immediately because of the impact of the pandemic in many communities. Many victims also are going to have concerns generated not only by their victimization of violent crimes, but they're also going to have concerns that we need to know about and we need to proactively respond to. And we'll be talking throughout our discussion today about many of those concerns. Many victims are concerned that an offender, even if arrested, may be furloughed or let out of the Department of Corrections due to the impact of the pandemic. Many victims are also concerned that their case may not be able to go to trial for a significant time when they're reading the newspaper and hearing about the backlog of cases, again, due to the impact of the pandemic. So the point that we really want to introduce is that victims are impacted by the trauma inflicted by the offender, but we also need to consider this in the context of the pandemic. And finally, we want to talk about implementing trauma-informed strategies that are really going to enhance our ability to prepare victims for their role in the criminal justice system, if we have that opportunity to work with them, but to always ensure their safety. And when we talk about safety, we're going to focus on not just physical safety, but psychological safety as well, as we'll discuss. These are just a few of the considerations that we all are giving a great deal of attention to. And when John and I reviewed the questions that you already provided, we could see that you're looking at a great number of these considerations as well. First and foremost, we want to ensure whether we're law enforcement professionals, medical professionals, advocacy professionals, or prosecutors, we want to make sure that our response to victims is as timely as possible. Again, support systems may have shifted, and sometimes for some victims, those support systems are not intact. So when a victim requests our service or our attention or our communication, we want to be timely about our response. Incorporating or integrating trauma-informed practices into remote interviews if we're using the Zoom platform or others, and also other virtual interactions. We're going to be talking about strategies to be as fully present to a victim over a virtual platform as we are when we have this opportunity to be able to speak to a victim in our office or in person. And always ensuring the availability of advocacy support is critical. When a victim desires to have the support of an advocate, whether a system-based advocate or a community advocate, we need to do everything possible to meet the victim's expectations and to provide for private and secure access, whether it's going to be through social separation with protective masks, or whether it's going to be done through another kind of platform. As we mentioned earlier, there are a number of concerns that victims have. Another one of those concerns is whether or not it's going to be possible to obtain a medical evaluation. And if that medical evaluation is done in a hospital or maybe even another medical setting, is that going to be a concern for transmission of the virus. So as you can see, we're building on a number of COVID-specific concerns, but again, in the context of a victim suffering the impact, the fallout of the crime that was perpetrated.
All right, folks, so we're going to start entering into some of the discussions we have, and we have a good range of discussions that were pre-submitted. However, I urge you, as we're talking, please keep the questions coming, and we're either going to handle them fresh or incorporate them into some of the other sets. We really want this to be a lively discussion and help as much as we can, at least with the time provided. So with that said, let me begin with one of our first questions, and that is this. What are some creative ways to connect with victims and increase levels of trust when personal contact is restricted? And a sort of a corollary or subset of that question is, because usually the common answer to that question about creative ways to connect with victims and increasing levels of trust is by using virtual meetings, using virtual resources, the sort of things I think that we sort of shied away from or didn't recommend in as much in pre-pandemic times, but that we're now has to be utilized as a resource. But trying to keep regular contact with victims, find out how they're doing, touching base with them, and also a practice that really goes to, I think, a lot of the issues here, because a lot of these issues don't have perfect solutions, really just ways to try to manage the challenges, try to leverage or increase as much as we can our multidisciplinary relationships by connecting with advocacy resources, whether it's going to be system-based, if you're prosecutors, folks in the victim witness folks in the office, and also your community advocacy that can also be there to support the victim and build that. A good question, and I think a deeper challenge for a lot of communities, is what happens though if your office or maybe the victim themselves or the region or area in which you're in has limited options for virtual meetings? What if you're living in a rural area that doesn't have very good bandwidth? Your office just doesn't even have resources for things like webcams or virtual meetings, or your victim doesn't have that. What are some ways you can still keep that relationship and that rapport building with the victims, even when personal contact is limited? One of the things, and sort of incorporate and sort of amp up, is in something that I tried to utilize when I was prosecuting cases, and cases could be prolonged or go on for whatever reason because of court backlog or just issues being raised. Trying not to reach out or connect with victims and witnesses just when there's an event coming up in a case, but sort of having regular chances to meet with them and touch base with them over the phone if necessary, touching base with them and just sort of building that relationship, even if there isn't anything particular going on. Now, of course, the caveat to this has to be too, we also want to respect and recognize victim autonomy. Some victims don't want that kind of in-depth relationship. They don't want to be bothered until the case is happening. And of course, we have to respect that and recognize that too. But we do want to work as much as we can about how to build resources as much as possible. And even when personal contact is restricted, if there are safe ways we can find out to even have some socially distanced contact to keep this relationship going, maybe even if it's not in our office or the courthouse, but a neutral area that feels safe for yourself and for the victim, then that can be one option too, and arranging meetings there. Patty, did you want to add to this question or add to this discussion?
You know, I think you really discussed it, John, but one thing that I would add to it is it all begins with the kind of relationship we build with the victim. It is acknowledging victimization. It is providing a depth of insight into the other features of victimization and answering questions before a victim has to articulate them. We want to take off from a victim's shoulders the responsibility of articulating a number of concerns, especially concerns generated by the pandemic. And so building that relationship with these features in mind, I think can be critical when we're going to be engaged sometimes in virtual communication rather than direct personal contact.
That's a great point, Patty. And I'm even thinking of one example, sort of anticipating these victims' needs. You might just sort of assume, talk to a victim, well, we can't meet in person. Can I set up a Skype meeting or Zoom meeting with you? And sort of putting that victim in the position where, gee, I don't know how to do that, or I don't have access to it. I don't even have a computer. I don't even have the resources for a good cell phone account right now. Maybe sort of framing those options as, hey, look, one of the things we can do to keep in contact is use virtual platforms. And if you're not familiar with that, we can help you set it up. If you don't have connections with that, then maybe talking about ways working with your community advocacy to make that sort of connection available with your victims, but not just assuming that your victims are going to have that way to those doors to connect with you. So did you want to add anything, or shall I move to the next question?
I think we can go ahead.
Okay.
So the next question was also a question that participants have asked us, and that is, how can we maintain victim privacy when operating with pandemic limitations? And so when we get into this area, we're talking about a number of different hearings that a victim may wish to be present at. There may be virtual hearings. There may be an arraignment or a bail hearing that a victim would like to attend, a pretrial, and then certainly testimony at trial. We're also going to be looking at the potential of virtual meetings. Perhaps the victim is meeting with the prosecutor and also desires the support of an advocate. So we'll be talking about that as well. And then making a record for needed accommodations during any court proceeding. At the core of all of these questions and concerns is maintaining victim privacy. Now, we all know that this particular virtual discussion is being recorded. We can see the red light on. We know that this is a recording. When we use Zoom and have an interaction with a victim, for the most part, if a prosecutor is speaking with a victim, we're engaging in what we would professionally call work product. However, there can always be a question as to the content of that communication and why we chose not to record when we did have that recording available. So what Sean and I are suggesting is, as allied professionals, we want to foresee some of the issues and prepare for those in advance. Now, when we're meeting with a victim, we also want to ensure that a victim knows whether or not the content of the communication would be disclosed for any reason. If we're dealing with a situation where a victim has provided additional information beyond the disclosure, this may be information that we would professionally be required to share. But we need to make all of these issues well known to a victim before. Not only are we talking about privacy, but there also is a related concern with safety. And safety has two very strong dimensions to it. One of those is physical safety, and the other component is psychological safety. Many victims have concerns whether or not the communication is going to be recorded, and if this will somehow be provided in discovery to an offender. So these are all questions about privacy when we get into any kind of a virtual platform. We need to know how this information is going to be disclosed and whether or not it should be disclosed. We had a great question come up just a moment ago, John, and I'll touch on that as well. It sounds like not all victims are being allowed an opportunity to be present in court when they want to. And so this gives us an opportunity as prosecutors to make a record with the court that the victim desires to participate and try to facilitate that participation through a platform such as Zoom. Again, working this out with the court and the other counsel and those involved in the criminal justice system is an important part of our work in the pandemic to make sure that we are honoring a victim's right to be present and to the level of security that's necessary. Many times, the court can also, at the beginning of any kind of proceeding that's being accomplished through a virtual platform, make it known to the public who may also be entering into the room through Zoom that there will be no recording and that all information that's being provided certainly should be respected as private. Some courts have actually taken that step. John, did you also want to comment on this?
No, I think you've definitely already hit the nail on the head, and the answer is, and it's not the easy answer, but just like even in non-pandemic times, a lot of what as prosecutors we're going to be able to do for victims is going to be eased by how much foundation and advanced work we can do. I think a lot of the challenges that are being exposed with pandemic restricted courtrooms and proceedings fall back on that old saw. Like the more we can do maybe to ease these issues or try to manage these issues through good pretrial motions and issues and litigation with our court and defense bar, not just responding in a reactive way, the more we can minimize disruptions to our victims. Now, maybe some of these disruptions we only realize or learn about as we're experiencing these new systems and learning about these new systems, but we want to try to be incorporating those lessons. In other words, with virtual hearings, if in our jurisdiction, these proceedings are broadcast to the public in a way that's invasive of victim's privacy, then maybe we want to figure out ways that the victim, while they're testifying, that they're not directly on camera, but still observable to a defendant if there's an evidentiary or cross-examination situation that's necessary. For virtual meetings, if there's concerns about privacy, just virtual meetings with our office, talking to our victims about what we're doing to protect their privacy during their channels, and also educating our victims too about things they can do to protect privacy, such as when we're giving them links to sign in, about how to making sure to keep those private and issues such as that. But just sort of proceeding that way. All right, so the other question that we've developed is how can we help keep victims engaged when cases are undergoing delays and other pandemic impacts? And other sort of variations on this question that we received and that I think is from what we've been learning about is pretty consistent challenges is discussing constant adjournments with victims of crimes. And it's always, the case is always going to be tomorrow. And trying to explain to the victim some of the benefits that have been given to the defendant and the vindication of defendant's rights and continuances requested by the defense due to COVID, and try to explain those things to victims. And I think these are challenging things for a lot of folks practicing in this system to appreciate and to deal with and to try to manage. It has to be even more frustrating to victims who maybe don't have the day-to-day familiarity or expectations of how the machinery in the system works and might have different other expectations about what's going to be happening. I think the best thing that we can do to try to manage this challenge and work with victims is, again, going back to sort of the touchstone about respecting them as individuals, giving them autonomy, trying to be open with them, talking about the trade-offs, talking about what's going to be happening in these cases, as much as we can, telling them what we know and keeping our victim informed. A lot of this can also be, in as much as our time allows, and making this time to work with victims, talking about how the system has been disrupted. And it's not the victim's fault, and it's not the victim's job to be satisfied with that, but just keeping them informed and educated with the issue. And most of all, letting the victim know and keeping the victim informed what you're doing to try to keep the cases moving forward, but also making sure the victim understands the context of what's happening in the broader universe of cases within our criminal justice system. So while it's not something that has to be appreciated, that hopefully it can be something that's understood, and what you're trying to do as the prosecutor or victim support services to try to mitigate the problem as much as you can and make clear to the victim that as they're frustrated by the delay, you're frustrated by it too.
And to follow up on John's thoughts, timeliness to a victim is a huge consideration. When I had the honor of serving as a prosecutor and sex crimes, domestic violence, and other related crimes, I spoke with so many victims who basically articulated that their lives were put on hold until they could achieve resolution of their case. And I think especially in the context that we're in right now, timeliness becomes even more of a critical factor in our work as prosecutors. I think we have the responsibility in advancing cases as soon as they can be logistically advanced, but also keeping in mind that any continuance is going to directly impact a victim. I think our communication with advocates and victims about the need for a delay needs to be clearly discussed, and a victim still retains a right to basically oppose a delay if that delay is injurious to the best interests of the victim. And if there is a delay that is requested that is not necessary, I think we can certainly bring to the court's attention the victim's concern, as well as our state's concern as prosecutors, and perhaps even make an offer of proof about how this delay is going to affect a victim who literally has reposed their trust in us to advance this case to the best of our ability. John, we just received another question that I'm going to segue into for just a moment. If the victim is told that a victim has to leave a court due to COVID, what do we do in order to provide the victim with necessary information? And the question was, should the victim have a record of the proceedings? And I think the answer really may depend upon the nature of those proceedings. In some instances in a trial, based on my experience, all witnesses would be excluded until the time of their testimony. And sometimes we would have a thought that perhaps even after that, maybe the witness would not come in until a certain time later, because we may need to recall that witness, or perhaps basically offer rebuttal through that witness. So there are some legal issues associated with it, but we can certainly, if it does not impact the case in that particular area, we could certainly provide that information. There are public records requests in every state. I believe every state has public records acts, which should also give us some guidance about securing copies of records when necessary.
The sequestration aspect is exactly the dynamic I was thinking about, Patty. Depending on the proceeding, if the victim has to leave, and you want to reserve the right to be able to recall that victim, we might not want to discuss the testimony that's happening when the victim is absent, so we can preserve them if we have to recall them for rebuttal or something of that nature. And that's a fantastic point. I mean, if those issues aren't implicated and our victim has a right to the proceedings and we don't think we're going to need to recall them, and that a chance to impeach them isn't going to be opened up, then I mean, we can make motions for those records to be provided or shared with the victim, and just and sort of show the cards we're playing with.
So our next question, again, which came from you as participants: how can victims' rights be protected, especially the right to be present during hearings and trial? If ever there were an opportunity for us to work together as allied professionals, answering this question truly represents that kind of a need. Prosecutors, advocates, both systems-based and community-based advocates, law enforcement professionals, and all other allied professionals who may be associated with the case should certainly come together and discuss the victim's need to be present during hearings and during a trial. We also want to ensure the physical and psychological safety of victims. It may not be possible for a victim to be safely present in a courtroom, especially if a court has reconfigured its prior structure and is using social distancing and sometimes even plexiglass within that social distancing. It may not always be possible to be present. If a victim wishes to be present in that room in a safe situation, we need to address that with the court and with the prosecutor with the help of the advocacy community. If this proceeding is virtually based, if we're doing this through a platform, then many courts are providing actually public links to Zoom, and a victim could certainly be supported in accessing that Zoom. Not all victims have iPads or computers, but again, working together, working with members of the advocacy community and social services, we can certainly offer victims that kind of technology so that access can be made through that link. When we offer a victim that opportunity, again, we've got to be ready to proactively discuss with the victim the nature of the proceeding, any concerns that the victim may have for privacy if the victim is going to be making any kind of a statement. Those are questions that victims have. So when we're discussing this initially, I think we have to advance those answers so a victim doesn't have that burden or responsibility of asking every question, but they still may be fearful of that proceeding, not knowing much about it. That's where we come in.
So, I think the only thing I could add or sort of add on to Patty's wonderful answer is when there's specific sort of issues or rights about the victim that we want to have protected and that don't implicate what we were talking about earlier with sequestration or not being present during other witnesses' testimony, I think we want to file motions with our court reminding them of those obligations and those duties, and with suggestions about how those rights of victims can be accommodated. I think it's also, though, important, though, to be talking to our victims and having conversations and deep conversations with them about what they might really want. There might be some victims who want to be present in the courtroom, but are scared to do so, either because of either the normal issues and witness intimidation concerns, but also compounded by health concerns. To help that victim make an informed decision, let's keep them informed about what precautions are or aren't available in our courts so that they can make a decision about whether they want to do that. Some victims, even if our courts are taking every prudent precaution in limiting exposure to pandemic infection, some victims might not be comfortable on any level, and it's we should be also respecting that decision as well. And if they're not comfortable in the courtroom, seeing what alternatives we can make. But whatever happens, helping our victims be informed about whatever choice they want to make that's going to that they want to pursue as just individuals. So what are some ways to talk to victims about their fears and concerns of an offender being released? And how can we help minimize the potential for future victimization? Well, one of the things, in addition, and we should have referenced this earlier, on our website, we have a variety of resources, including some references to webinars we've done in conjunction with CNA and NDAA about some of these issues coming up in the context of COVID. We also have some written resources on issues related to domestic violence and COVID, but we have a large library of resources related to issues of victim intimidation, because of course, victim intimidation, victim harassment, it's going to be all too common a risk or concern anytime when there's a pre-existing relationship between an offender and a victim. And of course, with intimate partner violence and sexual violence, all too often and almost always, the offender is going to have some sort of pre-existing relationship that they can exploit with the victim and get access to the victim. So one of the things we want to do to hopefully minimize the potential for further victimization is when it does happen and when we are aware of it, by following up on it, by charging it when that's appropriate and when that's supported by the evidence, by pursuing consciousness of guilt theories and instructions at trial, by making motions to revoke for bail and just make a record of that. But in addition, even sort of a preemptive thing that we want to try to do rather than just respond, but to minimize it, we want to be talking to our victims constantly and developing that relationship about how these risks can happen. Some of our victims might only be conceptualizing witness intimidation and retaliation as being explicit violence. And of course, working around these cases, you understand it can be a lot more subtle and a lot more nuanced, especially by offenders that have developed the ways in which they perpetrate their crime over a period of serialization and a course of conduct. And so we want to talk about our victims that, hey, look, anytime the offender or the offender's family or social network is talking to you about the case or making you feel guilty about the case, that's something that should not be happening and something that we want to talk about and proactively discussing with our victims what, if any, contact's been happening, not waiting for our victim to sort of reach out to us or to be their own investigators with these issues. In terms of ways to talk to victims about their fears and concerns of an offender being released, one of the ways we can talk about is by maintaining our credibility with the victim and recognizing that when an offender is a high risk of further violence or in flight risk and of contaminating the case, basically, show the victim through our arguments with the court about the risk that these offenders present and asking for continued containment if that's appropriate. But other than that, too, having open and honest conversations about the same sort of issues and concerns and trade-offs that we're facing in our office, but inviting victims into that conversation too, and keeping them informed, not only what the defense is arguing, what the arguments of the court are considering, but what we're trying to do to counter that and how we're trying to do our best.
And we touched upon this earlier, that most victims, I would submit, especially during the pandemic, have direct and immediate fears that an offender is going to be released due to the spread of COVID-19 in Department of Corrections facilities. I think that is an example of a concern that in our initial communication with any victim, we need to discuss how that potential motion for release would come about. If it is generated by a jail or by a facility, as prosecutors, we're entitled to that notice. That matter is then heard by the court, and making sure that a victim and the advocate working with the victim has this information is critical. There should be no surprises in this regard. And certainly as prosecutors, we're entitled also to take our position in not agreeing to a release if that request is not necessary. And in terms of the pandemic and the spread, we'd be looking into, are there other options for guaranteeing the safety of the offender in that particular setting? If not, what does that release look like? What are the conditions of release? The victim's security and safety is paramount in our considerations as prosecutors. And this is an example of proactive communication with victims. A victim may not feel comfortable about articulating this concern. So this is information that we can provide to a victim in the beginning of our work with them. A question came up regarding preparing child victims for trial. And I think in this area, without straying from the focus of this question, I think we can answer that because it's our ability to be present to a victim, a child victim or an adult victim. That's the cornerstone of building a trust relationship. Another feature of that trust relationship is anticipating concerns and providing information, which in effect will empower a child or an adult by having those concerns addressed when sometimes there's not a comfort level in specifically mentioning them to us. So I think this is an important feature of our work. And in this way, we can also help minimize the potential for further victimization. If an offender, for example, is contacting a victim will be advising us that that's happened if we've already laid the infrastructure for that kind of contact. And John already went into that area as well, but I think also for those in jurisdictions where jail phone calls are operative, need to really work with the Department of Corrections and work with victims so that we're notified if there are calls from jail. And as we know, offenders can communicate through other offenders in a jail system. So we need to be aware of this kind of contact and then address it with the court should it ever occur. But the basis for this is providing information about what we can do in our initial contact with the victim.
Great points, Patty.
So our next question that again came from you folks as participants, how can we spread awareness to our communities about the problems that are faced by victims of crimes and the efforts that we're making as prosecutors to protect the public? I guess in my heart, I'm always going to be a prosecutor, so I still feel very much included in the work that all of you are doing. And I think that the core of our answer to this question is it's the work that we do for and with victims. That's the positive that we accomplish as prosecutors. Whether or not we have victim satisfaction surveys, and in some jurisdictions, these are being used very effectively, and we gain a lot of valuable information to it. The cornerstone of our work and our ability to spread awareness to our communities of the work that we do as prosecutors comes from each and every individual contact that we're privileged to have with victims of crime. It also comes from our work with the advocacy community. And advocates are great friends of victims and certainly of our system. It's thanks to the work of advocates that victims are supported and making their voice heard. And it's the work that we do as prosecutors, along with advocates and victims, that literally is the basis for spreading awareness to the public. It's the work that we do on every individual case.
So, and the only thing I can add to what Patty so eloquently stated is, as prosecutors and as prosecutor offices, we really have a unique and potentially positive platform in our community. And as part of our obligation to make the community aware and let the public be aware of how their resources are being expended. And some of the times, a lot of prosecutors' offices are doing that through social media type efforts, so that there doesn't have to be a middle person with press media, proactive community efforts. And those are good things. And the issues and challenges that we're facing in cases and efforts we're making to meet those challenges is something that can be exposed or revealed through those efforts. But the other thing is either recommitting to our multidisciplinary relationships with other disciplines, law enforcement, community advocates, medical providers, whoever in the community, and just trying to unify our resources, and corral our expertise, each other's expertise, to almost be a force multiplier, to make sure we're each acting as one another's voice about the challenges being faced and what we're trying to do to face those challenges. And that can be, and that sort of strength in numbers can be a wonderful asset and amplifier as well. So sort of, I think, relating to this area, we do have a question: how have prosecutors dealt with required victim surveys when we are not permitted to see victims in person? Well, one of the things with of course, victim surveys, I think hopefully we want to give victims the opportunity to provide that input, both so we can improve our own practices and so we can learn from victims. Sometimes, though, victims don't want to participate in these surveys, and we want to give them a way to have an out as well. I think also, though, as much as we can, we want to give as many ways for a victim to offer that input as possible, not just in person, because of course, in person, a victim might not feel as free to be as candid if we're there or if our representative is right there. So hopefully the other thing that we can develop both and beyond the scope of pandemic concerns, and if permitted in our jurisdiction, is trying to make victim surveys or victim feedback resources available either through anonymous surveys that can be returned through the mail, maybe online surveys and such as that, so that we can get that feedback. And even if there's a risk of a victim giving double responses, giving victims as many options as possible about how to give that feedback, I think is always positive and conducive for victim autonomy.
And I think this also goes back to the question of how do we establish rapport with victims if our communication is virtual? And, really, we all have that potential of being present to victims, just as present as we are if we're seated together in a room. It is what we offer to victims, the commitment to listen, to hear what victims are saying. That's at the essence of our work as prosecutors. So even if we are not seeing victims in a physical setting, we still have this opportunity to be as genuine and as present as we have ever been, even though it's coming through a different kind of platform. So this leads to our next question of how can we encourage victims of intimate partner violence to reach out for help? And, first and foremost, we go back to the work that we do as allied professionals for victims. And we go back to how information about what we're doing and our working relationship with other professionals becomes known and certainly communicated through many positive examples in our community. We have to be certainly focused on obtaining a fullest amount of information about medical services, advocacy services, therapeutic services. This information should be generated in public settings with victims made to feel encouraged to seek services when they have that need. This is a major question that many victims have due to the impact of the pandemic. Am I going to be able to speak directly to an advocate? Am I going to be able to present for medical care when I'm concerned about the impact and the spread of COVID-19? This is the information that hopefully working together as allied professionals, we can be generating in our communities. This would be certainly a viable source of encouragement for victims, knowing that this help is available. And again, if there are resources for victims to communicate electronically, we need to make those available as well. The second part of the question is how can we connect with special populations like immigrant communities who may not be reporting? And I think at the core of both of these questions is the first question to be asked, if a victim is able to make that disclosure. And it takes us back to how we started. Victims are impacted by trauma, and they also are impacted by the forces of the pandemic that may have shifted their support systems, to use an example. So our voices as allied professionals need to be heard within our communities about the work that we do and the resources that we do. To try to connect with special populations, some of the best ways of accomplishing this is learning from professionals who serve these populations how to best do that and how we can play a role as prosecutors or other professionals in opening the gates and making possible a report of intimate partner violence. Some jurisdictions are encouraging electronic communication and requests for protection orders. There's a lot of information about abilities to make this happen for victims. So certainly another means would be to be working with prosecutors in this area to enable victims to reach out for necessary services and support.
Well, and I think that hits the nail on the head. And folks don't know what folks don't know. And I think the only way you can remedy that or solve that is by building relationships and introducing and challenging maybe some of the stereotypes about what as prosecutors or law enforcement, the criminal justice means, and really how our goal is to support victims. And we do that by, I think, building relationships, not just reaching out of the blue to leaders of these communities and advocacy organizations. A lot of folks just sort of sometimes think of multidisciplinary meetings as, oh, well, I've got my SART team or domestic violence team, and we got someone from the community advocacy, from law enforcement, from the prosecutor's office and the hospital, and that's it. But we really do want to be thinking of more expansively and talk to leaders and organizations of other communities that are in our neighborhoods and make up our jurisdictions, so that they get to know us and we get to know them, and maybe hopefully demystify one another a bit in the process too. So another question we have, and this sort of overlaps with the question we got about working with child witnesses. One of the questions is, how can we work with victim services to make sure that crime victims are getting appropriate services? And sort of related to that, what if parents of a child victim are not supportive? So the first part of this question, I think sort of overlaps with a lot of the suggestions and approaches we've been discussing or suggesting throughout the conversation we've had this afternoon in my time zone. To making sure victim services make sure that crime victims are getting appropriate services. We want to be talking with victim services and asking them how, one, become aware and educate ourselves as to what kind of services they're offering, working with them and asking about ways that we can facilitate them communicating and informing victims about the services that are out there and getting that outside in the community, whether it's victim resources for support during prosecutions or investigations, or even if folks aren't participating in the prosecution, what can be done to still support victims. And so that we can sort of know the resources that are available for victims and we can direct them to. Now, the other question, what if parents of a child victim are not supported? In the way we receive this question, it also suggests or asks if the parents of a child victim are not supportive, but also haven't maybe crossed the line into maybe their own criminal activity or intimidation or things like that. But one of the things I think we can try to do, and these are always difficult cases and child abuse cases that are especially challenging, where the non-offending parent isn't supportive of the child, that's a instance or chance that's ripe for attrition or that child victim not being able to participate in a prosecution. But I think one of the things we want to do is, and there can be a tendency to want to try to villainize the non-offending parent really quickly. And before jumping to that conclusion, one of the things we want to try to do is maybe try to have some understanding that non-offending parents, try to see where they're coming from and give them options to resolve that. In other words, if the non-offending parent is doing it because maybe they're dependent on the offender for financial, emotional ties, or maybe because there's some sort of cycle of abuse, is there anything we can do to mitigate those issues with the non-offending parent that might make them better positioned to support the child victim? Sometimes, though, that's a tall order and that's a big challenge. But we also want to try to, in the spirit of trying to understand where the parent is coming from, we want to try to be communicating with them for as much and as long as is possible. Trying to find out if maybe what we're interpreted as not being supportive of the child victim is whether it's maybe that parent really just worried about the impact of the adversarial system on the child and they're just trying to be protective on the child. And these are things that maybe that non-offending parent doesn't necessarily volunteer to us and might have to be unpacked. When it is unpacked, what can we do to alleviate or correct those concerns? Worst comes to work though, and maybe the non-offending parent really is being obstructive and truly is being obstructive. We want to be making sure that we're keeping open in communications with Child Protective Services or similar such agencies. Increase efforts about educating our non-offending parent about the risk to the child and risk to the child's development from continued or potential exposure to the abuser. And also, just from an evidentiary and prosecutorial perspective, we want to try to be especially alert to evidence that might show the offender sort of acquiescing to any wrongdoing by this non-offending parent that might make the child unavailable. Because if that happens, and if there's evidence that shows that, we might have an opportunity to present statements the child is given through forfeiture by wrongdoing evidence. But throughout, when we have issues or confronting challenges with a non-offending parent, both pre-pandemic, during the pandemic, and post-pandemic, if our child victim has made disclosures of abuse to our non-offending parent, we want to get those memorialized and hopefully get the non-offending parent memorializing whatever the child reported to them, so that we can potentially have those available for child victim, for non-testimonial statements being admissible under tender years or other hearsay exceptions in the event that child becomes unavailable.
That was great, John. I just wanted to add a thought to the first question. How can we work with victim services to make sure that victims are getting appropriate services? I think we need to ask a follow-up question to that. Are services available? Not all agencies are able to provide a specialized service that may be necessary in some case. And the fact that they're not available doesn't mean that they can never be available. So we need to ask for what is necessary, what is existing, and what else do we need to do to make this better. I think that we have the opportunity as service professionals to advance our work and to seek new resources for victims. And I think this would be a great time to do it. Again, we're talking about trauma in the context of a pandemic, where even additional services may be necessary. And if the parents of a child victim are not supportive, as John indicated, we need to try to determine what that is. And there may be a need for supporting the parent who is not in a position or is not able to offer support to that child through some other services. Counseling may be in order, but it all begins with finding out what's going on. If the offender is involved, we may be looking at forfeiture by wrongdoing, the admission of certain statements that have been made. If the offender is not involved and a parent simply is not being supportive, we have the opportunity as allied professionals to reach out and try to make support available to that parent, because in the end analysis, that is part of the work that we do for the child victim.
Okay, so I think we're on the wrap up right here. We're going to give our contact information shortly.
I just wanted to say it kind of goes back to how we started, recognizing the signs and symptoms of trauma and the impact of the pandemic on the victim. Getting there first. We know what many of these concerns are, and we need to answer those questions without that burden being placed on a victim to articulate concerns. And then, as John and I have been discussing with you, we need to really integrate trauma-informed strategies into all of our work. We've talked about virtual platforms. We've talked about trying to be as present to victims in a virtual setting as we are when we have the privilege of meeting victims in person. And we talked about trying to be aware that psychological safety is important as is physical safety.
All right, so, and I'm going to jump ahead and provide our contact information. This is Patty's contact information. And here's my contact information. If you didn't have enough time to get Patty's, I think these slides will be available for you to review later on. But Patty's email is just like mine, but instead of J. Curlin, it's ppowers@equitasresource.org. Both Patty and I would love to dive in deeper to some of these questions that we've delved into during this conversation, or any other issues or challenges you're facing in your jurisdictions that you just want to have a brainstorm or sounding board on, or want to see what other resources are out there. I'm going to give Patty the last word in a moment, but I want to reiterate appreciation for CNA and the NDAA for hosting this forum today, inviting us at Equitas to be a part of it. And I especially want to thank all of you for participating in today's discussion and giving us such provocative questions and that lend themselves to such great conversation. And not least for the work you do with victims and pursuing justice in your communities. Thank you so much. It has been an honor and a pleasure.
And I join with my colleague, John, in thanking NDAA and CNA as well. Your leadership in this area is amazing, and we all benefit from your focus on these cutting edge issues during the pandemic. Thank you so much for allowing us this chance. And thank you to all of the prosecutors and advocates, law enforcement professionals, medical professionals, and others who are here today. It goes without saying that we appreciate so much the work that you're doing in the field and the courage in advancing the rights of victims, and you do this at every turn. So it's an honor to be with you today. And if you'd like to contact John or I with any questions or any follow-up, we'd love to hear from you. Thank you again.
Thank you, everyone.
And we want to thank Patty and John for their time today. And thanks to these efficient presenters, we were able to get to all of the questions. But if you do have additional questions, please contact John and Patty directly, or contact CNA at COVID-19_courts@cna.org. We also encourage you to look for the email bulletin that CNA and NDAA send out to keep you informed of what we're doing to help support prosecutors and court staff during COVID-19. Thank you and enjoy the rest of your day.